He actually walked in there, to try and see if he will use his clout to get him out. Of course, by this morning, within the party, the celebration would have been that's the results man. He got us a result. And then, before we know it, we are now being told that another hopeful who says he's considering, he set up a committee to advise him whether he should contest or not. He is the one that the lawyer is saying that should be praised. But the substantive question of law, does the pendency of the application to vary the bail conditions stop or frustrate the continual processing of the bail application?
Samson, and thank you for having me. First of all, I think that the whole process is being colored with partisan politics. You see, and even the scenario you have cited, the competition among MPP presidential hopefuls to demonstrate a kind of kindness and to make themselves visible is another way of politicizing a criminal procedure. You see, and for me, I always think that it is important we divorce those partisan political energy and emotions from the legal issues. They are normal. It is normal for someone to exercise or express some kind of emotions to things you have common interest over and which are being heard, whether legally or illegally. But I think we should not allow those partisan political energy to obfuscate the situation. First of all, let me make these comments. The security apparatus as we have it, I don't think anything has changed. The status quo is what it still is, because the change of government is just less than 6 months. And so the security and their modus operandi is what we still have. And for me to have people of a certain caliber to now complain about the high-handedness or despotic tendencies of the security service. Now, when we had witnessed a lot more of these things, is worrying.
Okay, so Osman, my direct question, if you can answer that first. We want to educate the public. From where you sit, do you agree with Dr. Kojo Pumpuni-Asante that the pendency of the application to vary the bail application does not stop the IOCO from continuing to process the bail application, and he could have been granted bail last night since they've gotten the security for it?
Well, I was coming to that, but this was a general comment. The pendency of the application is intended to vary the bail condition. Now, if you file that application and you are taking steps also to meet the bail conditions, I think that the pendency of the suit will not hold off any legal steps being taken in the criminal procedure, because a fulfillment of a legal obligation or right, freeing someone of his liberty, is a legal duty on the people who are holding him. And so if you go to court, you file an application, I don't think that application should stop them from doing what they have to do under law, if the circumstances avail those things.
Or ultimately, what he would have done was perhaps change the character of what they are seeking. Would have said, what you are seeking, you have already complied. You have already fulfilled it. Is that not it?
Yes, of course. We have situations where we have moot cases, right? You can have a matter pending in court and something will happen to render it moot. And that this means that it is no longer relevant for the court to determine the issues that have been presented.
So the question now is, why will Iyoko be telling the lawyer that because of the pendency of this application, they can't go on? And the lawyer tells us publicly that the pendency of the application frustrates his ability to get bail for his client last night. That is if Iyoko is the one that told him so. But who else?
Well, we are all speculating. But if Iyoko says, because you have filed an application before the court, we are no longer taking steps, the point is the bail granted? Or because of the application, they have withdrawn the bail, the police inquiry bail? Now, if the police inquiry bail is not withdrawn, but it still stands granted, then you cannot stop the accused person from taking steps to meet the bail conditions to release himself. So for me, the filing of the application, though I think some other applications, remedies are available that could have been used. The pendency of the application, in my opinion, does not stop the pleas. It does not stop the accused person from taking steps to meet the bail, the conditions of the bail that has been granted him.
Right. So they can actually be treating the bail process today and tomorrow without waiting until Tuesday, when perhaps this application will be withdrawn or will be heard. Because you don't even know if the court will say 50,000 is too much. Because as we have shown, the court in recent times have given bail conditions of 200,000, 200 million, 670 plus million, and so on and so forth, right?
Yes. So you see, we lawyers always want to explore remedies. In fact, we fire all cylinders, as they always say, in situations where we want to free our clients from the clutches of the law. And so for me, I don't think the lawyer has done this with all his hopes on it. In fact, it is not a guarantee that you appear before the court and you get the conditions varied. In fact, it is possible that they might be increased. But it is an avenue of redress that he seeks to initiate as a matter of time, because all legal processes, the earlier you start them, the better, especially in circumstances like this. Is
it not an urgent situation, and I'm getting into that what some people may say is a faulty position or preposition? Is it not an urgent situation? Why urgent because it's Wontumi or what? That's the question people will be asking. Where in the Martin Kpebu line of cases, the court has held that weekends and holidays should not apply when it has to do with the liberty of a person. So a bail can be treated either it is weekend or holiday. So shouldn't they, even if they want to use the court process and they want it as quickly as possible, we understand that he's not exactly well, shouldn't they be pursuing it now rather than wait until Tuesday?
Well, that's why I think we are speculating. Is there any evidence to the effect that Iyoko or the security personnel are holding off on this legal process because it is a weekend? I don't think we have that. The point is, what we know is that the accused person is trying to meet the bail conditions. Whether they have had the required terms, they have had the people, the sureties, and all the things required to meet the condition is what we don't know.
No, we know for now from the perspective of the lawyer. The lawyer says Brian Champong has offered something of the value in excess of even 50 million. But the only stumbling block, as at 8 p.m. last night, was that Gary Nimako had filed an application to vary the bail terms.
Oh, if this is the situation, I think I would not agree with Iyoko or whoever is detaining the person, because the pendency of the matter we all know that pendency of a matter, the Supreme Court has just decided something in the nature of that.
We like that.
That the pendency of a certain injunction did not stop certain processes. You see, but
that's only about injunctions. And let's be clear about it. It's not every injunction that when it is pending, it is not in force. It is only injunctions that are against, as it were, the state or constitutional
obligations.
Exactly. So it's circumscribed. It's not general. People should not be misled.
But it's even worse if it is just a mere suit without an accompanying application for injunction, isn't it? That I sue you, and all of a sudden, the subject matter over which I sue you has to be frozen until we finish the dispute. That's not it. Otherwise, even the application for injunction, interlocutory injunction, will be useless. Because that is always done to hold up the status quo, to hold the status quo until the final determination of the matter. But be that as it may, my point is that the pendency of whatever suit has been filed should not stop the processes that has already been initiated.
You have made that point. You were saying, and I'll take you finally on that. You were saying that there are other avenues available to them. They are interested in his liberty. Can you share with us what these other avenues are so they can get him out of detention?
Apart from applying for variation of the conditions of the bail, I hear arguments to the effect that the detention of the man even now is illegal, it's unconstitutional. Okay? If it is unconstitutional, I have my personal opinion about it because the dispute is over whether he's released or not after being granted bail and waiting for the terms of the conditions of the bail to be granted. And these things are not determined by public debate among lawyers. They are determined by the court. And the courts help us to know the position of the law. So these things should have gone to court. But one of the, if you believe that the detention is unlawful, I think habeas corpus application is also available. Now, you can't make a habeas corpus.
They are looking for quick processes. They are looking for quick things that could get him out rather than resorting to court. I thought those were the kind of suggestions you were going to
Yes, but the quick things, like Samson, the quick things are what the lawyer is doing. In my opinion, he is focused on getting the bail terms met and get the gentleman out. And in fact, he's not going to be out as acquitted and discharged.
Right. Thank you. Hold on for us.